So, good evening to you all. It's a very good evening. Yes, we are going to start a special session. Right, today, of course, is just an introduction, but this introduction is very important to you, right? Because the very first thing you must know is that the nature of the exam, right? Because if you look at law college syllabus, right, you can see law of contract, you can see law of administrative law, right? And international trade law, of course, a part of commercial law too at the final year, right? So what is our expectation? If you think that you are not going to sit for just administrative law paper or law of contract paper, or international trade law paper, this is something different, right? Because we know you all are graduates, law graduates, right? So from law graduates, rather, I don't think, and I know it very well, right? The law college is not expecting you to present the legal knowledge, right? Or rather, I can say information, right? For example, if the first topic we are covering is law of contract, first subject. So they will never ask a question like, what is a contract? Right? What is the difference between a contract and an agreement? Right? That is for first learners. Right? If you're a first year student, of course, yes. Right? To identify simply the difference between contract and just an agreement like social agreement. But when it's come to the special entrance exam, right? Something more, right? Definitely will cover all papers, or it means all required papers, right? No. But they are doing at the law college, for example, at least two papers from 2024 and two papers of 2025. Four papers at least we're covering, right? But that is not the real expectation of the law college in the special entrance exam. You must do more, right? If you, I think you may go through the syllabus, right? So, frankly speaking, it is not the whole syllabus of the law college law of contract, similar to law of admin and international trade law. International trade law is something different, right? It's a part, shipping part also there, right? What you have to do is first you can just learn the theory part, or in other words, I can say refresh your memory, right? So if you're foreign graduates means you study the English law. So English law, you have what you have to do is refresh your memory, right? Plus you have to add some Sri Lankan law parts to that, right? For the end of the theory sessions, right? What you'll get is redo the English law part plus the Sri Lankan law part and some kind of application. Right? During the paper class time, that is the theory part, the paper class time will cover the law college past papers and we'll do more and more model questions. Right? That is the best method of preparing yourself, because this is something about how you can look at this, look at a practical question, right? The analytical skills, right? Whether you can correctly identify the issues, right? Those are the things that check at the law college, because passing these three subjects, right? Just pass these three subjects is not a difficult task for you, right? Now, this is the third exam, so you know what kind of exam you have to face in the future, right? And the nature of the exam, everything, right? If you have no idea, we will explain it, right? We'll give you a very brief, you may get some idea today, but more than that, right? In the subject wise, I will explain later what are the most important parts you have to look at, right? And exam techniques, right? Writing things, right? Because there's a specific space to write and you have to summarize it, or you must know how to write the answer, right? Because it is very not a lengthy one, right? Of course, you can go for more papers, but that is not the thing. The expectation is to write a proper, strong answer, right? So that is this thing, right? Hope you can see the screen. Right. Okay, so please give me few seconds, right? Few seconds to share the PowerPoint.
प्रभातයකට අහස් සදිදුලන්න අනාගතයේ තොර කවුරු ඇරලන්න සිනාරෙව් දෙන මාවතට පිවිසෙන්න විරහසේ ආගගැස්මට එන්න විරහසේ
Pramuka Law School.
Right now you can see this presentation. That's it. This is just a guideline, right? Hope you all receive the document, right? It's like what I shared earlier. Right? The same thing of this presentation, right? So basically, now we are going to talk about the Sri Lanka Law College Special Entrance Examination 2026. This is not about the first exam, not the second exam. This is about the new exam, right? So basically, there are small differences. We'll discuss it. Okay. There are 3 subjects: law of contract, administrative law, and international trade law, right? So if you look at the law college things, right? The law of contract is a first year subject, administrative law the second year subject, and international trade law the third year subject. Okay, right. Then basically these 3 subjects, the law of contract, more or less about English law in Sri Lanka, right? More or less. If you go to the commercial law part, the commercial contracts, right, mostly talk about the English law principles. But in general, there's a considerable part in Sri Lanka governed by the Roman Dutch law. Right? Many concepts from English law plus a small few concepts from Roman Dutch law. But the thing is, though it's few concepts, right? If you're going to give an answer for a question, you have to think both sides, right? You have to think both sides. You can't write an answer based on English law or only considering the Roman Dutch law principles, right? You must know how to balance it, right? Then administrative law, basically, it's about English law, but not the whole thing, right? Not the very in a Sri Lankan course, for example, just look at the proportionality principle, right? Our folks is very reluctant to use the proportionality principle, right? Not like in other countries considering proportionate principles, right? Like that, you have to clearly identify, yes, it's based on English law, right? But we must know the clear difference between English law and present Sri Lankan law, right? Another example, if you consider the judicial error, right? There's something, right? Don't worry if you don't know these things. It is totally okay, right? The application about this thing, right? In anismic place in English law and present in Sri Lanka, People's Bank versus Sathapathu is a different application, right? Even writ, right? Different application is, you can find a different application here based on the constitutional law principles, right? So we'll discuss it later. And it's come to international trade law, right? It's a part of commercial law too, the final year subject, right? That area basically, there are main three areas. We are going to look at the international trade part. Important legal areas come under international trade law, right? Okay. So the exam at a glance, right? So nature of the examination, it's conduct only in English, right? So the classes, right, it generally conduct in English, but based on your request or understanding that if there are no students who has the difficulty in understanding Sinhala, right, I will give small explanations in Sinhala. Since the Sinhala is mother tongue for many of us, it's easy for us to discuss some concept in Sinhala, right? But it depends, right? It depends on the class, right? If a class is almost all, right? All the class members asked to conduct only in English, I will do it only in English, right? Okay. Now you know there are 3 compulsory papers, 1 hour per paper, answer 2 out of 3 questions, and basically 100 marks per paper. For 1 question, 50 marks, right? For 200. Pass mark of the subject is 40%, right? Okay. So if you can get 40 out of 100, you pass the subject. But the problem is, right, the selection based on overall merit, not minimum pass and on. It's like general entrance exam. The general entrance exam, basically there are 3 subjects, right? 3 subjects, right? Of course, you can pass the subject. But the problem is, just pass the subject is not enough. So you have to work a lot, children, right? Work, it's a very hard working. Hard work is essential for this exam because you have to score the maximum, right? And it is not a difficult task. Like we are at the beginning of March, right? We have enough time, right? We have complete 3 months. So study. That is more than enough to study this part, to do past papers, to do model exams, and having some discussions, right? It's very important. It's very easy thing, right? The studying part, the only thing that whether you can focus enough, right? Your attention is very, very important, right? I can't press you to switch on the video, right? Cameras, right? But if you can do that, it's very helpful, right? So this is an introductory session. We don't know how many students will be in the class, right? Because the interactions are very important in exam like this, right? Because our main purpose is not limit to explain the theory, right? You're graduates. So why I need to decide teaching you theory? No, that is not the thing, right? I'll refresh your memory and I'll introduce you the Sri Lankan law part, right? And the differences, applications and everything. And I'll come to discussion with you the model questions, right? To enhance your understanding about the theory, right? And the last sessions at the end of the month, right? We have to do some mock exams as well, right? Because timing and everything is very important. Okay, right. So key message to you. This is not a memory test, right? Please remember, right? If it's an entrance exam, it is not about a memory test, right? It is a legal reasoning and analytical writing examination, right? This message is very important, right? Keep it in your mind. So basically, what is examiner's expectation, right? You must know clear legal principles, right? According to Sri Lankan laws, right? According to Sri Lanka, clear legal principles. What are the applicable principles from English law, other things, and our specific judicial decisions, right? When it's come to source of law, the statutory law is there, and after that, the case law, right? So you must know most important. Simply we say the leading cases, right? Or the cases with authority. You have to know the principles. Then structured answers. How to write the answers in. So basically we are using IRAC method, right? You have to read the question at least 2 times and identify the issues. So based on that issues only, you can write the answer, right? Then application of law to facts, right? If we consider the IRAC method, the application part is there. I for issue, R for rules, A for application, and C for conclusion. So application is there, right? And the examiners will check your awareness about the Sri Lankan legal positions where relevant. If it's very similar to English law position, it's okay, right? But remember, so this entrance exam is a very competitive exam, right? So always write the questions based on this, questions mostly based on the different principles, different areas, right? Not very similar areas or a mix, right? Similar to English law plus these crucial areas, okay? And the case law familiarity, right? You must be familiar with case law. It is very, very important, especially in contract and administrative law, right? But remember, right, though we are going to be familiarized with cases, we are not going to cite everything, right? So it's a fair, right? It means that if you want to explain one principle, if there's a specific case for that, explain it. That is more than enough, right? More than enough. No need to explain the same principle with 3-4 cases. There is no such requirement, right? Okay, right. So now we are going to look at subjects, right? And about its strategy. Before that, do you have questions? You have questions? No. Right. Okay, children, we'll look at subjects then. The first subject we are going to cover, especially in this month, the law of contract, right? So based on the syllabus published by the Law College, the 4 areas tested is formation of contract, capacity, consideration, and justa causa, terms and exclusion clauses, vitiating factors, remedies for breach, and dispute resolution mechanisms. Right? Basically 7 areas, but we'll discuss some more, right? Not a very, no deviation, but if we want to understand some different areas, right? So I will explain it briefly and give you a brief note on that, right? To clear your understanding of the subject, right? Otherwise, no deviations. We stick to this part and we hope the exam also stick to these 7 areas, right? So why this subject is crucial, right? The reason is that this you can find English law principles plus Roman Dutch law principles, as I explained earlier, right? The majority of English law principle and minority of Roman Dutch law principle, especially justa causa, but not only that, there are other principles as well, right? Especially regarding breach, fundamental breach, vitiating factors, we have to consider some Roman Dutch law concepts, right? And it's always required to do a comparative legal thinking, right? Comparative legal thinking. Compare with what? Compare with English law and present the Sri Lankan position, right? And based on a previous experience, right? Most students fail due to poor structure, not lack of knowledge. Of course, you have enough knowledge right now, right? Maybe it's only about English law, right? But it's also enough, right? What you have to add is this unique Sri Lankan themes, right? Unique Sri Lankan things based on Roman Dutch law or its application, right? So remember, when it's come to Roman Dutch law, we have indigenous Roman Dutch law. What is that? Indigenous Roman Dutch law. It means, right, the Roman Dutch law principles are very old, right? And that at that time, right, very in our history, our courts interpreted it, the principle. So you can see some slight changes sometimes. Sometimes you can, in some cases, the court used current South African law, somewhere the Roman Dutch law concepts. Right? So it depends. That's why that case law study is very important. Right? You can't find an act about law of contract. There is no such act. Right? There are a lot of things like if you are going to do an agreement, do a contract for an immovable property, you have to look at prevention of fraud ordinance for sure. Right? And if it's just an agreement, commercial agreement, maybe sales of goods ordinance applied. On the top of that, you have to look at unfair contract terms. There are some statutes, but there is no specific statute for law of contract. Right? So to find the correct law, what you have to do is you have to look at case law plus statutory law. Right? I very simply explain that if you talk about the formation of contract, right, you have to look at common law principles like offer, acceptance, consideration, Roman Dutch, Buster Cosa, many things, right? Capacity, everything. But that is not the only thing, right? Those are the requirements come under common law. Common law in the sense English law or Roman Dutch law. Right? Apart from that, you must know the statutory law requirements. Right? What are they? The requirements come under prevention of fraud ordinance, sales of goods ordinance, right? Unfair contract terms, so on. So that is the nature of this thing, right? So don't worry about it. I'll explain everything in detail. Yeah, I got a question. Yeah. There's a question asked, do we need to discuss the rules according to both Roman, Dutch and English law, like in case where consideration and justa causa? Yes. Right? Yes. So if it's a problem question, you have to apply, right? This is a Sri Lankan law situation. Right? if there is no consideration, right, but there's a reason, there is a something come under justa causa, you can say there is a valid contract. Okay. Right. Thank you for the question. Right, let's move to the next one. Okay. Right. So that is the thing, something about English law enrollment, Ashu. So required comparative legal theory, right? You have to compare with this English law and the application. Otherwise, you can't apply it properly, right? If you have enough knowledge on case law, present case law, you can cite it, but it is something else. The main cases you must cite, right? Apart from that, there is no such requirement, right? But you have to do the correct legal analysis, right? That is the essential part, right? Then when it's come to contract law, what I can see even at the law college, that is very poor structure, right? Not lack of knowledge, right? Especially in the law college, we called it not law of contract, law of obligations one, right? So I was there as a permanent lecturer for 14 years, right? That's why I did it. And was there as the head of the examination for 4 years. Now I'm totally resigned from the law college and doing my own practice. Then what I saw, my experience was this poor structure, right? Because there are a lot of cases, even 100 cases. Then students, they really want to write it up. Then a lot of things in the memory. So they try to write them. This case, that case, lot of cases. So that is not the thing, especially the special entrance exam. Don't try to do that, right? Don't try to do that, right? You have to study, right? You must study, but you can't write everything at the exam. But of course, at the college, there is no minus marks, there is no limitation for the answer, right? Not like in graduates, that for graduates, we look at the presentation. Right? There must be a very good presentation that I can't say there is no such at the law college. The law college is a professional institute, right? They look at the structure, but not like that much serious and no minus marks, right? So students, from student side, it's bit flexible. Then they can write, if they have a good writing speed, they can write more, right? But you can't do it at the special entrance exam. With special entrance exam, you have to stick to a particular question, right? And you must be very careful about your structure, correct answer structure. Okay. So no, there is no such thing. If someone say that you don't have knowledge, that I will never accept it. You may not remember every concept at this moment, but it is in your memory. What you have to do is refreshing it. You have enough knowledge, right? Without me, even without Pramuka Law School, you can do the exam. But here, what we are doing is supporting you to find the best thing, right? Right. Example question. Discuss whether consideration is essential for a valid contract in Sri Lanka. Right? We will never get a question like this, right? But we have to we must write answers for questions like this. And then only we have to clear our knowledge about these things, right? So the question say whether consideration is essential. So what is the expected approach? If we talk about the consideration, that is the constituent element of contract under English law. So first you have to discuss the English law position. English law position. Why? Without English law, you can't introduce consideration and what is consideration and everything. The first thing, English law possession. Then you have to come to Roman Dutch law concept of justa causa. Right? So there's a concept called justa causa under Roman Dutch law for a valid agreement. Right? The justa causa is essential. Right? And basically, now you already introduced what is consideration and scope, justa causa in scope. The third step, you have to write the judicial approach of Sri Lanka. What is our position? What is the Sri Lankan position? Right? Use it, right? There are cases we will give you, right? You have to cite at least 2 cases, best is 3, right? To justify your answer, right? Sri Lanka is talking about the justa causa, not consideration. If statutorily say it must be consideration, yes. Right? For example, if a sales of goods ordinance, right, it talk about the consideration, not just terms. Okay. So if it's statutory requirement, right? Statutory requirement is about a consideration. We have to stick to that. Otherwise, generally, because this is ask about the contract. Yes, just goes and right. Right. Then you have to conclusion with authority. Okay. Right. Then questions, right? No. Okay. Next, what is next? Administrative law. Core topics. It's about judicial review. Then under judicial review, we will discuss something about what is Hydra virus. That was the very first concept, right? But we are going to study from this point GCHQ case or judicial review. Under that, we'll discuss illegality, rationality, and procedural impropriety. Illegality, there's a different ideas even at the law college. When time to time the lecturers explain uh, different things. So the present situation is that present lecture at the law college is talking about illegality generally. Right? He did not divide into subparts, right? So we are using our own way to explain it. And at that time, I'll explain you how to write the answer based on illegality. The second principle, Wensbury rationality and procedural impropriety. Present lecturer that divide the procedural impropriety into 2. First one about the statutory requirements, the second one about the natural justice principle. Right? And also there's a emerging rising concept proportionality. He really likes it. So let's talk about the rationality and proportionality difference and issues with the proportionality in application in Sri Lanka. And then it's come to natural justice. The lecturer explain in detail about natural justice 2 principles, Aureorum Partum, and also the bias principles. So we have to study them in detail, and it's end with legitimate expectation. Again, 2 types, procedural and substantive, and its application also different. We will study it in detail, right? And the meantime, that's different applications, especially the end result, right? So this end result is we can apply for a writ, right? So type of writs, its application, its legal basis, and simply though this is not listed on this side, I'll simply explain you about ouster clauses, 140 that writ types of writs and its application, and judicial error concepts, right? Very briefly, we'll discuss apart from that. Otherwise, you can't identify this illegality correctly, right? to identify the illegality, you must know the legality. Okay? Right. So it's up to me, right? I will do that. That is my responsibility. What you have to do is you have to follow my instructions. Of course, anytime you can raise your own view, we'll discuss it. And after that, you have to do that comparative legal study. Right? This is high scoring. If you know the subject, you can go for high score easily. And also, it's high risk subject. Why? Why? One example. Now, there are mainly 3 grounds for judicial review. Right? Frankly speaking, we can say mainly 4 grounds based on the law college lecture. Illegality, irrationality, procedural impropriety, and proportionality. Okay. So let's say it's 4 grounds, right? 4 grounds. Then if you consider a problem question, right? The facts of the case, you may find all 4 grounds. All 4 grounds in one question. There's illegality, irrationality, procedural issues, proportionality, everything. My God, then how to write the answer? Right? How to write the answer? You must find the most important ground. Most important ground. You know the law very well, that it is not enough, right? What you have to do, find the most important ground. Maybe rationality, maybe illegality. It depends, right? So that is the most difficult task at administrative law, right? So what is the expectation is to write the most important ground on. Even at the courts, you can see some lawyers, they introduce more than one ground. Most of the time, 2 or 3 grounds, right? But that is not the technically correct thing. What you must do is to find the most important ground, right? So if you have a doubt, right, this is not the expectation, right? If you have very serious doubt on that, what I say is write for a second ground, right? If you have a very serious doubt only, right? Because the examiner's expectation is to find out the most important ground, right? Most violated ground, in other words, right? But at the exam, you know, it's a very stressed time, right? You may think illegal, irrationality, illegal, method irrational, right? Like that. If you have no idea, you can write that, write the second one as the second round, but hope it's very clear to you, right? What is the expectation? Find out the most important one. Okay, that's what I say. Like that, the other things also same. Is a high scoring but high risk. If you pick a wrong ground, right? No marks at all, 0, right? If it's a wrong ground, හරිම කල්පනාවෙන් බලන්න. If not, right, you may get marks, but not the full marks, right? So it just comment on examiner's mindset, right? He wants arguments plus position, right? You have to give your clear argument, right? But not the argument that you can argue in this way and you can argue in this way, not like that. What is your position there, right? Especially on proportionality, because proportionality in Sri Lanka, I told you at the beginning, even it's very reluctant to recognize or apply, right? So you have must be very careful, right? And also, in this subject, the examiners expect a significant weight from cases like administrative law, where contract law, there is no specific statute for law of administration, right? No specific statute. Contract law, you can find other statutes even, but not for administrative law. So main source is case law. Lokuma source actually. It's almost all based on case, right? So case law discussions are very, very important for this subject. We'll do it in April, right? Syllabus is, of course, is a very small one, but we need some time to discuss these things. Okay, right. For example, should proportionality replace Wensbury unreasonableness in Sri Lanka? There's a question. It's asking in every problem question, is it basically about one ground, even though there is more grounds? Yes. Yes. Right? That's the difficulty. You have to find the most important ground. Right. Should proportionality replace Wensbury unreasonableness in Sri Lanka? Then you will how to write the answer. Not textbook repetition, critical thinking. Right? So first you have to identify whether we recognize this Wensbury unreasonableness and what are the cases with facts. Then come to the proportionality, right? Explain what is proportionality, its application. There are a few questions asked about. At that time, we'll discuss them later, right? Then the application in Sri Lanka, what are the barriers it had? Why courts are very reluctant to apply it? The reasons, facts, everything, right? You have to explain, right? You have to critically evaluate it. Okay? These are small theory questions, right? I told you why I put questions like that, right? To clear out your knowledge. Okay? And finally, our last subject, international trade law. The scope of subject, there are three key areas. International sale of goods, right, about passing of property, performance obligation, trade terms. When it's come to Sri Lanka, it's sale of goods ordinance. Then what happened internationally? Some are same principles, some are different principles. We'll discuss them. And carriage of goods, right? Hague Bisbee Rose Bill of Lading, that is from shipping law part, its application and our 1982 Act and all we'll discuss. And financing international sales, right? Documentary credits and collection agreement. We'll discuss them in details, right? So there are small few adding points also, right? That's the purpose of, again, to get a very clear idea about the subject, right? So basically, I'm not going to do deviations from the scope, right? But sometimes I will add some parts to improve your understanding, right? To improve your understanding, right? That I'm not going to talk about the international trade law history, what is the Asian position, what is the Sri Lankan position. No, we are not going to discuss in that extent, right? Stick to this part with small add-ons, right? So examiners' focus in this subject is understanding commercial risk allocation, right? Right, this how I said this, that I went through the scope that I did the review and say, right, based on these things, right, passing of property, performance, obligation, all are talking about what? Trade terms, KBSB rules, bill of trading, or all talk about the commercial risk allocation. Why passing of property is important means pass the ownership. Passing of property means pass the ownership. Right? Why it's important? Risk goes with the ownership. Risk goes with ownership. Okay. And your ability to explain why rules exist, right? And finally, the relationship between contract, courage, and finance. Look at these three, right? It's talk about contract, talk about the courage of goods and finance. So basically, you must know the relationship between these three. Okay, very simply, when you can do this work, right? Example question. Discuss the legal significance of bill of lading in international trade. Right? So what is bill of lading and all? It is sometimes it acts as a document of title. Right? Sometimes it acts as evidence of contract. And sometimes it's a receipt of goods. Right? That person received the goods. And also it talk about the transfer risk. There are exceptions, but basically the person who's with the bill of lading has a risk. Right? So here the examiners will test your skill about commercial legal reasoning and not memorization. Okay? Right. Okay, so that's all about the subjects, right? Frankly speaking, we are going to discuss the subject in details later, but I really want you to explain the scope, right? Then you know what you are going to do. That's the most important thing. Second one, you know how we have to work, right? It's a full-time one, but it doesn't mean you have to sacrifice 20 hours per day, right? But you have to work every day at least 2 hours, right? It depends on your pattern, right? But make sure we have New Year season and all next month, but you have to work, children, right? So 2 hours from 24 hours is a small amount, very small amount. Right? පැය 24ක් දවසට තියෙනවනේ. අපි පැය 8ක් නිදාගත්ත කිව්වත් පැය 16න් දෙකක් තමයි වැඩ කරන්නේ. But every day. Right? Every day. So keep in touch. Right? Ketama touch එකේ the subject එක. Right? Okay. So how Pramuka Law School prepares you? So our teaching method, it's basically exam focused lectures. Right? I told you that I am not going to take the responsibility of giving you the knowledge. Right? Since you're graduates, right? You can do it your own, right? If you have a proper note, right? What you all need is a proper note. Or you have to do your own research and find the theory part, right? So our expectation is to prepare you for the exam, right?
Can I ask a question?
Yeah, yes, please.
Yeah. Means, are you going to give complete comprehensive notes or we need to find our
Yes.
notes?
No, I will give a complete note.
So we don't need to go for somewhere else to find the notes and all if
No,
we follow
not at
your
all.
coaching.
Not at all,
Okay.
right? I prepare it by myself and I'll give it to you. Because I have more
Which
than
includes all the
14
case
years
laws
law
and all.
college experience. What?
Yeah,
Sorry?
which includes all the case laws and all. Cases and
Exactly,
all.
yes. Exactly, yes.
Okay.
Right.
Thank you, ma'am.
Okay, welcome. Right. And we'll do model answers and issue spotting, right? I will prepare you separately about to follow the IRAC method. That is a small special you can see in our that flyer even, right? You can see the theory class time and paper class time. So at the beginning, I will explain you what is IRAC and its importance, and you have to be very familiar with that thing. Then I'm not going to repeat it as the administrative law and international trade law because at the end of this month, right, and especially at the end of the law of contract, you must know it very well because the most important thing is finding the issue, right? What are the issues we have to discuss here? Not other things. Don't look at the topic, right? It is not about finding the topic. For example, if it's law of contract, if you say, right, this is question based on consideration. No, that is not the thing, right? Okay, consideration. What is the issue? Right? It can be about a past consideration, right? It can be about insufficient consideration, right? Like that. So you must find the particular issue, not the particular topic. Okay, right. We can do it right during the paper class time. And past question patterns, there's basically two types. I told you this is not equal to law college exam papers, but to that familiarizing with the subject is very important. So we'll do past paper questions, 4 past paper questions from the law college, attorneys and law examination, and a lot of model questions. And available, there is no available thing for international trade law, but for other things, right? Other 2 subjects plus because last 2 years international trade law that the third part, right, the commercial law part only it's limited to shipping law, right? So we'll do those papers too, right? But we have to do more and more model papers, right? And structured writing frameworks I will give you, and during the class you have to write. Okay. Earlier we asked you to ask you to write answers and send it to us, right? But only 1 or 2 students did that. So this time I decided actually, right, to do it during the class, writing answers during the class. Okay, right. And continuous answer evaluation, we can, if it's a small number, we can do it at the class, or we can do a group work, right? Whatever. And also time to time, right? I will check students separately, right? Individually, right? At least one time I have to look at your own answers, right? To check whether your handwriting is clear enough, right? The way you present, right? So during a discussion, it's not a difficult thing for you to find a good structure. But I must know whether you can do it your own, right? We have 3 months, so I can pick one by one and check your answers, right? Okay, and what makes the difference? Children, that I don't know whether you will join my classes or not, Pramuka, whatever it, right? Whatever your decision, right? Please remember these 4. Understanding what not to write, which is very important, right? For you, it's not a difficult thing to understand what to write, right? But the difficult thing is what not to write. Second one, learning how much to write, right? You know the law, right? You know deep concepts even, very deeply. But you must know how much to write. Third one, learning how to conclude the answers. If you follow IRAC method, It's not difficult for you because C part is about conclusion, right? The conclusion must address the question. For example, if it's asked to advise someone, the conclusion must be the final advice. If the question asks, do you agree or something, the conclusion is yes or no, and your reason, summarize your reason. Summarized reason. Right? And the time management technique. That's why we divide the class into two. The first day for theory and the second day for answer writing. Okay, right. So from my side, this is the final message to you. This examination is not about brilliance. It is about clarity, structure, and discipline. Right? Okay, not about your knowledge, right? What a deep knowledge you have, right? That is important, but remember, it is about clarity, structure, and your discipline. So we will help you with proper guidance, focused preparation, and exam-oriented answers. Right? So remember, with all of these things, right? You can easily pass the special entrance examination. I mean, not the passing the subjects, right? To select to the law college examinations. Right. So that's all from my side. It is not a very lengthy introduction, right? It's a small introduction. So it is now it's your time to ask questions or any clarifications. I'm here to reply you. And also our admin is present at the moment. We can give you some answers, right? So now only I can see your names. Right. Okay. Right. It's your time. This presentation in the PDF format shared in chat. No questions, all clear. Oh, very good, Bresh.
I believe all the recordings will be provided
Yes,
on
yes.
immediately basis,
Yeah.
not after 4 5 days. Am I right,
Yes.
ma'am?
Yes, yes. All provide. Right. If you miss a class, make sure that you will ask for the recording and notes on time.
Okay. Because we
Right.
are in a
The
different time
benefit of
zone,
yeah,
we may not be able to attend full-time class.
no problem.
I'm in Middle East, yeah?
Sorry,
Oh,
Ahmed.
I'm in Middle East. I'm in Middle East, so I
So,
won't be able to
yes,
attend.
I
I'm
can
not sure.
understand,
Yeah.
but yeah, but you have to do weekly, you have to take all necessary recordings and notes. So follow it carefully. Sorry, I can hear you.
Yeah, okay, okay, ma'am. Thank you. I
There
got
is
it.
a sound. Okay. Right. So don't, I can't say it's waste, right? Don't miss time. Are 3 months enough to study? Yes, of course. Yes, of course. Not boasting myself. I was the only permanent lecturer for 14 years at the law college. Yeah, there were a few lecturers, but I was in the academic staff at the beginning as a tutor. Right, I'm invited academic based on my exposure at the law college in 2010. Right, when before I took course, I joined as an academic to the law college staff. So that is not a very good thing or a marvelous thing, but I have a lot of experience there. And the last year I worked in 2024, I was the head of academic, and before 4 years I was the direct examination, and the whole time I worked as an academic. So based on that experience, I didn't assign any university or anything after that or before that. But based on that experience, what I can say is 3 months, even 1.5 months is more than enough, right? So don't worry, it's enough, right? Because the last time we did only around 2 months, right? This time we have 3 months. Definitely you can do, and don't worry about it. I just share my experience, not for anything, right? To if you believe me, right? I know it because the children, even the law college students, they will study only for 3 months and doing 8 subjects at once, right? There are a few questions. The procedure of the lectures, like, do we first finish theory and then start writing answers? It depends, right? Depends means general ways we are doing a theory part one day on Friday, and we'll do a paper class on a Saturday. So at the beginning, the paper class, it's scheduled for 2 hours, but maybe only 1 hour. But later, it takes time, right? Because with your full knowledge of the subject, right, we have to do more and more classes, right? Well, don't worry that I told you it's enough time. Okay, that's all questions and another question. Last year special entrance exams that I can't say the exact number, right? All data with Pramuka. So please contact them. I just went through the students who did not select, right? So there are a lot of students who requested for recordings, right? Not attend classes online, right? So if you know the exact percentage, please contact our admin, not this admin, this is IT admin, our admin for more information.
Ma'am, do you have oral examination?
Sorry,
Do you have oral examination? No. Only written, no?
oral examination for special entrance?
Yeah.
No,
No.
no. Only written exam, yes.
Okay.
It's a 1 day exam, 3 papers. So today is 2nd of March. We are going to start.
Ma'am, is it all 3 papers in a day or 3 days?
Yes,
All 3 papers in one day.
yes. I
Okay.
don't know, there can be changes, but for now, yes.
Okay.
1 hour per paper. So 1 day is enough, but for us, it's difficult. Right? So relax yourself that this is not a difficult task, right? It's difficult if you're not worked for it. Right? After this, also you can see in the screen the Pramuka Law School. It's about the general entrance examination, LL.B entrance. LL.B entrance means for the Open University of Sri Lanka. It has a separate exam. Or USL also state university, but it's not the based on A level, is it? Oh, and we have a separate diploma in law. It's may not important to you. And we have the law college general entrance exam in the Tamil medium and special entrance exam what you are going to enroll right now. And also we have LL.B internal, and I can't see in the screen right now. Even for attorneys at law classes, we'll conduct at, through Pramuka Law School from coming May. Right? I'll ask admin to share the recording to the group, right? So admin, there's a request to share this recording to the group. Good question. This time enough to write each whole paper in 1 hour? Of course, yes. Right? That is the difficulty even, right? That's the most difficult part, right? I told you we have this clarity, structure, and everything is important. The reason is this. Very competitive exam, right? Yeah, admin say yes, that he will share the recording with you. Okay. So be relaxed. We'll do the work very well. Not a difficult thing. Identify the theory part and do the papers. And after that, you're ready. Right? Another important thing. Right? You have to control your stress. අපි කොච්චර ප්‍රපෙයාර් වුණත් වැඩක් නැහැ. ස්ට්‍රෙස් එක ලොකු ස්ට්‍රෙස් එකක් ඔළුවේ තියාගෙන හිටියොත්. That we can't do that. Hari, from our side, we can say, right, there is no reason for that, right? No reason to be upset or with stress or anything, right? So we'll do our best. And from your side, you can do the same, right? You can do your best. That's all we can do. There's nothing to worry. It's just a only problem is a competitive exam, right? So we'll do more and more. ඒකට අර ගොඩාක් තියරි ගොඩාක් බදාගන්න එක නෙමෙයි කරන්න ඕනේ. they analyze කරන එක තමයි කරන්නේ. That's why I told you that if it's a way too long answer or the answer with lot of unnecessary things, that you can't even pass the exam. Right? So you must be very careful. Right? We have 3 months. So more than 90 days. Enough. Okay. Right, so that's all from my side. No questions in chat, so we can conclude the sessions. We can conclude today's session, so hope I can meet you on Friday for the first law of class. Sorry. No, there is no extra time to read the paper. There's no such thing. Right? It was a suggestion, right? But as I know, to the best of my knowledge, there is no such thing. Okay. We don't know whether
Oh,
we
excuse-
conduct the class, say exam.
Hello,
Sorry.
ma'am. Ma'am, I'm late for the meeting, so I have a question, ma'am.
Yes.
All the lessons will be provided, no? You will provide all the
all-
lessons and all the handouts. You will give us.
Yes. All notes plus all recordings.
Okay.
Yes, full note. We will provide you a full note.
Okay.
Right, based on the syllabus published by the law college. And if there's essential additional readings, we will provide you that part as well.
Excuse me, ma'am.
Yes.
Do we have, the twice a week classes, right? The Friday and Saturday, or only once a
Friday
day?
and Saturday. Yeah.
Okay,
Friday
Friday
for
and Saturday.
theory.
Yeah. Friday 7 to 9 and Saturday 7 to 9,
Saturday
I guess.
7 to 9 years, same time.
Okay, then notes are providing by WhatsApp, right?
Yes, yes.
Okay, thank you.
As I know, yes. Is that admin? That right. I'm totally out of this administration part, right? As I know, yes. But you have to give your email and register there, right, to send recordings and all. Right? You can get the lecture note, class note before the class, right? If you have time, you can go through and come. Otherwise, that we can discuss it at the class. Right. Okay. Right. So then, thank you very much. Right. If you want to contact me or contact our admin, can just drop a message to WhatsApp. If you have any difficulty like attending class or anything that you want to know about time allocation, the things that just drop us a message. And if it's something about the academic part, I will reply you. And put about the admin part, that Pramuka admin will reply you. You can see now in the chat the WhatsApp admin number, right? Though it's academic or administration thing, just drop a message to it, right? Then I will receive all academic things, right? Your inquiries, and within 24 hours, will reply you. Right. Okay, children. Now, thank you very much,
Okay,
and
thank you.
wish you all the best. Right. And the students who registered with us will meet on Friday for law of contract first class.
प्रभातයකට අහස් සදිදුලන්න අනාගතයේ තොර කවුරු ඇරලන්න සිනාරෙව් දෙන මාවතට පිවිසෙන්න විරහසේ ආග ගැස්මට එන්න විරහසේ ආග ගැස්මට එන්න
Pramuka Law School.